Morning. We'll call this meeting to order. This is the October 14th, 2013, meeting of the Tennessee Real Estate Appraiser Commission. First item of business is the roll call, beginning at my right. Please give us your name and where you're from.
Eric Collinsworth, Arrington, Tennessee.
Rosie Johnson, Paris.
Norman Hall, Brentwood, Tennessee.
Michael Green, Johnson City, Tennessee.
Mark Johnstone, Jackson, Tennessee.
Nancy Point, Rogersville.
Tim Walton, Collierville, Tennessee.
Gary Standifer, Franklin, Tennessee.
Thank you. Are there any objections to adopting the agenda as it's been submitted? Hearing none, the agenda for today, as published on our website on September 25th, is adopted. This regularly scheduled commission meeting is taking place in the first floor conference room of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and notice of this commission meeting was posted on the TREC website on September 25, 2013. Has everyone had a chance to review the minutes from the last meeting? And is there any changes or amendments? And if not, I'd like to hear a motion to accept those.
So move.
Second.
Okay, we have a motion and a second. All those in favor?
Aye.
Any opposed? Hearing none, the September meeting minutes are accepted. Next item on the agenda is the education report. Ms. Avers.
We have 3 courses on the education report that are ready for approval. 1692 Eminent Domain from start to finish by the NBI Incorporated. The 2014-15 USPAP from Georgia Appraiser School LLC, which is course 1693, and the NAIFA course 1694 Residential Narrative Report Writing. Dr. Barilla reviewed all of these courses and recommended approval. We had 2 individual course approvals requests. David C. Horner, he applied for 34 hours of continuing education credit for course 102, Income Approach to Evaluation, which was from the International Association of Assessing Officers. Mr. McDonald submitted a course matrix. However, Dr. Barilla did not have time to review that last one, so that's the only one that Dr. Barilla had not made a recommendation on. Staff recommends approval of all other courses. We'll have to have Dr. Barilla make a recommendation at the next meeting for Mr. McDonald, which would be December 9th.
Ms. Avers, just a quick question. When these that have been approved, when were they submitted to us, and when did Dr. Barilla look at them, roughly?
I'm going to have to field that to Mr. O'Brien.
Dr. Barilla looked at those about 2 weeks ago because they all came in at different times, but Mr. McDonald's came in last.
Okay, and about how long?
I had been back and forth with him on filling the matrix, no course material. It was like, well, we had to squeeze whatever we needed out of him, and that's the best we got. So I sent it to Dr. Barilla last week, and for some reason, I think because of the file size, it didn't transmit, so he sent me an email saying, please send it again, and I did.
Okay,
So
all right.
that was just last week.
So Dr. Barilla approved these other ones 2 weeks ago. He apparently received them 3 to 4 weeks ago,
That is correct.
and this last one came in roughly a week ago.
That is correct.
Okay. Was there a lot of material as part of the last Mr. McDonald's request?
It was more
Roughly.
Mr. McDonald not being able to come up with the actual course materials because at the end of the day, he has sent us copies of some course books that he had used. He was just not able to come up with the matrix. I had to send him some weeks ago, actually, and I do have an email trail on dates and times, but we had to send him a matrix that someone else had submitted to give him an idea of how he might be able to tackle this submission. And based on that, he came up with a matrix, but then there was no course material to back it up. We had no idea what he had built his matrix on.
Let's see.
So when he finally got the course material to me, it was just copies of the sort of early parts of some kind of a course book that he had used. And he's admitted that even the university from which he took it couldn't help him with the course material because it was so old. And he just pulled out books from, his own personal stack that I guess he could locate when we had asked him for it. But he had quite a bit of trouble getting his stuff together so that we could review it properly.
Okay. Well, and we will urge Dr. Barillo to process this as quickly as possible.
And the course had been approved before 2008, but when the requirements changed, the University of Memphis didn't submit this course for approval. So the course expired prior to 2008, and he took it in 2009. I don't know why they were continuing to offer the course despite the fact that they hadn't submitted a matrix, but apparently they did.
Who's going to be the instructor for that course?
It's not a future course. He took this course back in 2009, but it wasn't approved in 2009. It was approved in 2008 and expired.
Well, he was only asking for credit, is that correct?
For qualifying education credit,
Okay.
he has to take the courses, and they have to be within the last 5 years. And he was a registered trainee, and he expired. So he has to reapply under on the current requirements. That would include the qualifying education.
Commissioner Johnstone.
Mr. Chairman, thank you. This is just a question from clarification, and I can't remember, but it seems to me that the education chair or the education committee member in '06, I can't recall his name, but he was an instructor at the University of Memphis that sat on this board. Would he possibly be able to help in that matrix preparation since he taught the course? I think if it was him, I'm not sure if it was him. I don't know.
Dr. Evans was the
Evans,
education
right.
member, and I believe he was somehow involved in Mr. McDonald's current matrix,
Okay, he's
but
involved
he
in this.
wasn't the instructor
He
for
was-
the
okay.
course in
Thank you.
2009. It was somebody else who worked it. I can't remember the guy's name. It's on the material.
I was just thinking that would have been a good source for the matrix since he was the education chair and worked there. But
They submitted 2 other courses for matrix approval, but they did not resubmit this one.
Well, and this, I think it's important to note, this topic comes up later on in our agenda, and I believe it's in the director's report, is it not? So as I understand it, Ms. Avers, you're recommending for approval of all the education except for the pending application that has not been reviewed yet. Is that
That's
correct?
correct.
Okay. Do I hear a motion to that effect?
So move.
Second.
Motion by Commissioner Hall, second by Commissioner Walton. Any conversation or discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries. Next item on our agenda is the legal report. And I turn the meeting over to Counselor Baird.
Okay, the first item is 2013008241. Complaint was filed by a consumer and alleged that respondent undervalued a residential property and stated that the foundation of complainant's home was not set up correctly, causing complainant to lose the loan. Complainant alleged that since 2009, he has upgraded the home with hardwood floors, ceramic tile, cabinets, etc., all of which was overlooked by respondent during the appraisal. Respondent provided a response to the complaint stating that this was a VA appraisal request and was completed following VA guidelines and procedures. Respondent believes that the complaint boils down to a disagreement as to the value of the property. Respondent stated the subject property was listed 15 months after his appraisal date for $160,000 for 198 days before the listing expired, and the property did not sell. I've listed the reviewer conclusions there, as well as the respondent's response to the reviewer's conclusions. So if you guys want to take a minute to read over that, and then we can talk about the recommendation.
I'll entertain a motion as to the legal's recommendation.
Legal's recommendation of a letter of warning.
We have a motion by Commissioner Point to accept the recommendation. Do I hear a second?
Second.
I have a second from Commissioner Standifer. Any conversation or discussion?
Yes. Notice as part of the comments made by the review appraiser, the three approaches were not reconciled. This was a VA appraisal, and under VA's guidelines, I do know that they do not require you to have a cost approach in there, nor an income approach, just to address the these things with a different criteria. I know they're supposed to be reviewing them. Appraisals are being done in accordance with instructions by the client, which supposedly all follow the same guidelines. I don't know.
If I may, VA requires a minimum compliance with USPAP, so they do have to reconcile the value opinions used, and if a value opinion was not applicable, they have to say so. That's standard rule 2-28. That's a minimum requirement, is that they reconcile the indications of value that are included in the appraisal report. Not that they'd automatically do it, but that they reconcile it, any that they do, or say why a certain approach was not applicable, so, or necessary. Either that's not applicable or it wasn't necessary for the client's opinion, but it still has to be reconciled.
And not seeing the report, the respondent said that they were reconciled according to VA guidelines and requirements, which would be in
I think too, the reviewer's task in these matters is basically to give us their full laundry list of things they think are applicable, and it's up to us. This is probable cause stage, so it's up to us to determine if there's probable cause and to dispense as accordingly. So the reviewer's function is being served in that manner, I think. So is there any other discussion? Okay, we have a motion to accept legal's recommendation in a second. All those in favor say aye.
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 Any opposed? Hearing none, motion carries.
Item number 2 is 2013-007651. This complaint was filed by a homeowner who was attempting to refinance a home and alleged that respondent performed an inaccurate appraisal report that contained numerous errors and omissions. In addition, the complaint alleged that the report demonstrated gross incompetence and possible negligence in its preparation. And the respondent didn't provide a response to the complaint, but he or she did file a response to the reviewer's conclusions, and it's listed there. If you guys, again, want to take a minute before we talk about the recommendation.
Once everyone's had a chance, I'll entertain a motion regarding legal's recommendation of a letter of warning. Commissioner Johnstone has a question for legal.
In looking at this complaint, it's showing a prior history closed with a letter of instruction. And for some reason, I still have trouble wrapping my mind around letter of instruction, letter of caution, letter of warning, and the hierarchy of which they are disciplinary. I always, in my mind, concluded letter of warning to be the highest level before you start getting into monetary type penalties, and then caution to be slightly under that, and then letter of instruction prior to that. And we have this is not the first time. I'm just, for some reason, it's just very nebulous and flopping around out there. I wish we had some concrete instructions on that.
A letter of instruction, caution, or warning really are the same thing. I think that I'm always prone to call it a letter of warning just because that's what I've always called it. Whoever handled the complaint back in 2003 apparently went with letter of instruction. It's really the same thing.
So those are all three the same things. But from a person reading that, as I read this letter of instruction, you think, well, it must not have been very egregious. But didn't, and then a letter of warning, it was more egregious, but didn't really rise to the level. I like those differentiations because it just makes, some things are just, it's really not a problem, just do it this way. And some things that's kind of a problem, but it's not so much of a problem that you really need to be spanked too hard.
And to be honest, when I write the letters of warning, it is worded like we're cautioning you about this. It doesn't say we're warning you to try to be scary. If you want to change it to, I can forever change them.
But it sounds kind of scary sometimes.
Yeah. We can forever call them letters of caution if that makes you feel better. Because there's no difference. And in the letter of warning, it does use the language, we are cautioning you, not.
I'll probably ask you that again next month.
Okay,
because
I might just go with letter of caution
was
from
thinking
now
you
on,
would,
just so we don't, I don't want you to feel like I can change it to letter of caution, it makes no difference.
But they're all
to
the
me.
same, okay.
They're all the same.
You could make your motion such that it's got the Johnstone touch, and if the
I
commissioners.
understand what you're saying, and warning sounds more severe than someone saying, we're writing you a letter of instruction. I know that they're all the same.
And historically, listening to the board for the last 7 years, caution and instruction were considered less of a shot across the bow, as it were, of saying, don't do it again. And we went back and checked the disciplinary history to make sure it wasn't the same violations a second time with anyone who had a history. It was checked. If it was the same violation, the recommendation probably would have been for actual civil penalty and education.
And let's be clear, all three of these, which are essentially equivalent in Ms. Baird's mind, none of these three letters go on their permanent record. None of them have to be reported on applications.
Well, anything is permanent. So any permanent record, it is in there. if somebody requested someone's complaint history, they would know that they had a letter of warning. It's not published to the subcommittee, but it is permanently recorded in the office.
Basically, it's just, in my mind, it's just placed in the file so that if something were to happen down the road, we can look back and say, they had
Well,
this.
I guess my concern is, does the appraiser, when he makes application for licensure or certification, and there's the question that says, have you been disciplined in another state or in this state, would this trigger them having to check the box? It would
Not
not.
discipline.
So this is not, that's my point. Yeah.
It
Thing
is
on
not
errors and
discipline.
emissions. I'm sorry.
Yeah.
Same things on errors and emissions insurance.
Not discipline. I mean, if they requested a copy of it, somebody could get a copy of the letter of warning, but it is not discipline. It just can be considered as a mitigating reason for more discipline in the future. If you've essentially been warned once and you still did it,
We're cautioned.
or cautioned, or,
instructed.
yeah.
Well, this being our October meeting, maybe we could make it Halloween somehow, like letter of haunting or. Yeah,
Good.
what do you
We can
think,
call it-
Commissioner
we can just
Johnstone? Would you like to
change
weigh
them
in on this?
forevermore to letters of haunting.
You spoke very well there.
I mean, it really doesn't matter to me. If you guys want to call it something else, I can certainly call it caution. It doesn't matter.
Okay, well, we don't have a motion on the floor yet, so is there a motion to accept or amend legal's recommendation?
Make the motion that we accept legal's recommendation for a letter of warning in this situation.
Second.
Okay, motion to accept by Commissioner Walton, second to accept by Commissioner Johnson. Is there any other discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? None opposed. Motion carries. Item 3.
Item 3, 2013-003-111 and 2013-003-112. This complaint was filed by a property owner who had purchased the property for the purpose of development and alleged unprofessional conduct, bias, failure to analyze highest and best use, failure to summarize information about the comparable sales, failure to summarize relevant property characteristics, and undervaluing a property. It's a non-residential property right-of-way matter. Respondent sent a response stating that all of the allegations made by complainant are denied. As of the date of the appraisal, the property was zoned residential R15. The planning director indicated no approved residential plat was on file. This matter was sent to a reviewer, and after researching the information in the appraisal, plat maps, and physical inspection of the property, the reviewer was of the opinion that an adequate analysis of highest and best use had been determined. The final plat indicated and stated the County Regional Planning Commission granted a variance on May 13, 2002 to allow this property to be designated as a non-buildable lot. No buildable permits will be issued until this lot meets all subdivision regulations. Plat also stated all shaded areas are to be reserved for subsurface and no house structures or driveways are to be in shaded areas. Therefore, as of the date of the appraisal, it supports the opinion of highest and best use in that it is not legally permissible to build on this lot. Changes to the appraisal alluded to in the complaint do not affect the value, and no value change was made in the appraisal. In summary, no use PAT violations were observed based on the reports, work files, and information provided. Since no violations of use PAT were observed by the reviewer, council recommends these matters be closed, no further action.
Do I hear a motion?
So moved.
A second.
Motion by Commissioner Hall, second by Commissioner Collinsworth. All those, is there any conversation or discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? None. Hearing none, motion carries. Item 4, please.
Item 4, there are also two matters that are sort of similar to the previous matter. 2013-005831 and 2013-005832. This complaint was filed by a consumer and alleged unprofessional conduct, bias, and failure to properly analyze highest and best use. Complainant also alleged respondent tampered with and changed the appraisal and did not give proper value to the improvements, such as the bridge crossing the river on the property, as well as a historic wall and other special features. Complainant alleged that when they purchased the property, it was overgrown and had not been maintained. and that $10,000 was spent hiring a land clearing machine, which came through and turned it into a park-like setting along the river. Complainant alleged the property is worth significantly more than the value assigned by respondent, and that respondent appears to be working directly for the city and not as an independent appraiser. And just to kind of refresh your memory, this item was on the legal report at the last meeting. However, I quoted the incorrect complaint number. So you guys have already made a decision on this, which I have restated at the bottom on my recommendation. There were just two similar complaints, and the addresses were very similar, and so I stated the incorrect complaint number. So you've already seen this once. It's just a different complaint number. But I'm just letting you guys know. So the recommendation is going to stay the same as what has already been accepted, but I have to put it on record with the correct complaint number, so that's why I'm reintroducing it.
Item number 4? Okay. All right. So legal recommends this matter be closed with no further action. Do I hear a motion?
So moved.
Second.
Okay. Motion and a second. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries.
Item number 5, 2013-013371. This complaint was filed by a homeowner and alleged the undervaluing of a residential property by misreporting the number of square feet of the subject property, which caused the complainant to lose the refinance and low rate. Complainant had the home appraised in May 2013 and alleged that respondent decided to use the same measurements that were done back in 2006 when she bought the property, failing to take into account the 300-foot addition that was made to the house in 2008. Respondent sent a response to the complaint, stating she acknowledges that on the original appraisal dated May 2013, there was an error in the total heated, cooled square footage of the subject property. However, complainant's assertion that she used the same measurements that were done in 2006 is without merit. Respondent stated she did have an older measurement taken in 2006 from a previous company that she worked for. However, she did measure the entire subject property from wall to wall on the observation date in May of 2013. Her error was in the submission of the report with the old sketch included rather than her new sketch and calculations. Respondent states this was an honest oversight, and that when the mistake was brought to her attention, she corrected the report and resubmitted it. It was sent out to an expert reviewer. The reviewer conclusions are listed there, and I stated on the legal report that the respondent did not respond to the reviewer's conclusions. However, she did turn in a response late after the legal report was already done, and that's one of the sheets of paper that I handed you guys. It should say item number 5 at the top. That's the response to the reviewer's conclusions.
Yes, sir. Commissioner Hall?
Did she provide any documentation to these courses that she said she had taken?
That I do not have any documentation on. Did you get anything on that?
Not in response to the complaint, but she might have submitted it as continuing education. hour of the submission, I didn't have time to go back and check to see if she actually did what she said she did, but I have no reason to doubt that she did.
We give them 10 days after, when the reviewers' conclusions come back. I send them a letter saying what the reviewers found, and they have 10 days to respond to that. And I had already put it on the legal report, and then that.
Question is, I reckon for you and for my fellow commissioners, would what she has done satisfy the education requirements that we are suggesting? I don't know.
Up to you guys to decide. I understand what you're saying. I mean,
I just don't want to overburden them. By the same token, I think they need to understand what the problem is.
Any other comments from other commissioners? The legal's recommendation is a 30-hour basic appraisal procedures, and the respondent in their response dated October 3 mentioned several courses that she's taken, and so Commissioner Johnstone.
I would agree with Commissioner Hall's assessment here, and upon reading this, it looks as if she's taken it upon herself to try to become a better appraiser, and so I agree with him on that.
Seems to have a genuine desire to do a good job and to better her methods and herself. So I think that comes out in the response. Now, is it proven yet? Probably not. But I'd like to make a motion.
I would move that we issue a letter of caution.
I'll second.
Motion with a letter of caution, a second from Commissioner Collinsworth. Any other discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Hearing no opposition, letter of caution is the motion and it carries. Item number 6.
Item number 6, 2013-007061. This complaint was filed by a consumer and alleged that respondent misreported property characteristics and used inappropriate comparable sales, which resulted in an unreliable opinion of value. Complainant alleged that this low value cost complainant money as well as the opportunity to refinance the home. Respondent sent a response to the complaint stating he did submit the initial report with an incorrect sketch, and the person who was responsible for delivering reports is no longer employed. Respondent stated that when it was pointed out, he immediately sent the correct sketch and stated there were very few land sales in the area, but the closest one was given most weight. Respondent stated he could find no evidence that the park enhanced or increased land value. It's a very rural area situated a long way from such things as shopping, medical treatment, restaurants, etc., and he does not typically put a value on timber, which is a natural resource. Respondent also stated the barn stable was not in use and not in the best condition. More importantly, there were no recent similar sales with a barn that would indicate or support a higher value. Respondent stated the single biggest issue was how the second floor was treated. The heating source for the home is a gas wall heater. The second floor, per the borrower, did not have a heat source, and it was not really needed for their purposes, and the only way to get to the second floor was to go through the 2 back rooms to the utility room in the back of the garage and up a staircase. Based on this information, it was respondent's opinion that this area could not be included in the gross living area. Had it been included, the value would have been closer to what the borrower was expecting. This was also sent to a reviewer. Their conclusions are listed there, and the other sheet of paper that says item number 6 is the respondent's response to the reviewer's conclusions. This one also came in after the legal report was prepared.
everyone's had a chance to review it. Looks like council's recommending 2 classes, report writing and case studies course for 15 hours, and then a second 15-hour advanced residential application course.
Mr. Chairman,
Commissioner Hall?
pardon me. Value of a property does not have anything to do with the requirements for reporting or for gathering data. However, it would appear from what we know, which is very little, this would definitely be a, quote, rural property due to the price being suggested or sales or whatever, which leads me to wonder how much data was really available to be analyzed in this particular location. It also appears that a great bit of discussion is being aimed at the state park. Well, once again, if you get in a rural area in this price range, I'm not too sure it makes a heck of a lot of difference, because most of the tracts of land around you are large, undeveloped tracts of land anyway. Yes, they might be developed, but in all probability, when you look at the present worth of future benefits, you're back down to almost zero. So I am just concerned that we might be asking this person to come up with information and data that might not be readily available, and relying more on judgment than he was on actual factual data simply because it wasn't available. I'm not too sure telling them how to send them to a course for residential report writing is going to help them when they don't have the data to work with. And advanced residential applications, same comment. I don't know what course could be recommended, but I am concerned when I look at what little information I've got here. What are we asking this person to do? To me, I don't know, it just seems like to me that without seeing the report, without knowing where it's located, just based strictly on what we were provided, yeah, I'm sure there's a lot of problems here, a lot of mistakes here. But by the same token, I don't know whether or not what we're requiring them to do would really solve the problem.
So do I hear you saying you don't think there's enough probable cause here? There's not enough factual issue to justify disciplinary action?
Maybe I'm all by myself on this thing, which is nothing unusual, but but you know, I just concerned when we get these reports in here that it's very apparent that this is a, quote, rural area where they don't have a whole lot to work with, and we're trying to hold them to a standard that was written for properties where you have got a lot of data available. And I don't know, I just have a problem with this.
Thank you. That's why we're here, is for that conversation. Commissioner Johnstone?
Mr. Chairman, thank you. Once again, my good friend on the other side there makes some strong points, which I agree with. It's obviously a rural property, and I represent an area that's full of rural properties. And the data many times is very hard to get and hard to verify. There's no question about that. And as I read the responses, some of the responses make sense to me. I mean, I have no problem with some of the responses in reference to the ANSI standards and whether the word some was used and connotating 3 to 6, all of these little things. I have to agree with Commissioner Hall on this. I think you have to look at the assignment in the context. It doesn't mean do a bad job. It just means sometimes there is judgment involved, and I think She clearly indicated some of that judgment in talking about the ANSI standards in a home being suitable, in an enclosed area being suitable for year-round use. What that is for a homeowner and what that is for the market may not always be the same. So.
This would be a good time for a motion, and then if there's more discussion, we can entertain that. But would one of you rural enthusiasts like to make a motion?
I'll yield to Commissioner Hall because I'm not sure in my mind I've reconciled what would be appropriate.
I would recommend a letter of caution to this person, but simply because I don't believe we have enough data right here in front of us.
Like to state that in the form of a motion?
I recommend a letter of caution.
Have a, is that a motion then?
Yes.
Okay. We have a motion from Commissioner Hall to issue a letter of caution. Do I hear a second?
I'll second.
Second from Commissioner Point. Any other discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Motion carries to issue a letter of caution. Item number 7, please.
Item number 7, 201-002-1181. The respondent in this complaint was required by final order to complete a 15-hour USPAP course and a 15-hour residential case studies course, as well as complete an 18-month probationary period, which included submitting experience logs and appraisals for review. There was also a required payment of investigative hearing costs in the amount of $2,935. Completion of the terms of the final order was due on August 27, 2013. The final order indicates that if respondent fails to complete the terms of the order, his credentials shall be suspended until the terms are met. The respondent had completed the 15-hour USPAP and the experience log requirements of probation, but after a request was sent to his office as a reminder of the requirements, the Real Estate Appraiser Commission staff was notified that the respondent was in the hospital. Ms. Avers granted an initial extension of 31 days to complete the terms of the order, and then a second extension to October 14th, which is today, which is 24 additional days. On October 8th, 2013, his office staff and the respondent's wife provided a doctor's note indicated he has been hospitalized since August 16th, 2013, and due to his condition, a discharge date has not yet been set. The director has never granted an extension of this type to a respondent for an extended period of time and has requested the matter be presented to the board for a recommendation on how to proceed. The extenuating circumstances of the respondent's serious medical condition warranted an unprecedented delay in implementing the suspension of his credential. The director and counsel recommends that the commission authorize the respondent's wife be allowed to submit an application on his behalf to place the credential into inactive status with a $25 application fee, and the terms of the respondent's final order be extended until such time as he applies to place his credential into active status. If the respondent's wife places the credential into inactive status by October 31st, 2013, then the suspension shall not be applied. Approval of this request would require an extension of the terms until at least October 31st. His credential does not expire until September 30th, 2014, so the respondent would have more than a year since his prior deadline date of August 27th to take one more 15-hour course and pay the costs identified in the final order.
Point of clarification. When you recommend that you authorize the respondent's wife be allowed to submit, will that carry with it some type of a affidavit that he will sign, or will he sign that application?
We're not even 100% sure, I think, of what he's capable of doing at this point, just because it's sort of, I don't know if it would require an affidavit on his part. I'm just not sure what he's even able to do at this point.
We haven't received any medical documentation, just a doctor's note. However, verbally, his wife told me he had pancreatitis and had to have his pancreas removed. and he's not in any kind of fit condition to do anything.
Well, I guess in order to maintain the public's protection and to some degree the commission's, I think it might make sense that no matter how grave his illness is, that his signature and his affidavit or his power of attorney or whatever documentation there is he needs to be an active participant in that. I think you set a dangerous precedent when you allow someone's spouse to submit anything on behalf of a licensee. That's my only comment. Commissioners?
Question. Oh,
Commissioner
Chairman?
Hall and then Commissioner Johnstone.
so Council, what we're doing, what we're being asked to do is to allow his wife to sign an affidavit putting his license into an inactive status. Is that basically it?
Allowing his wife to submit an application to put it on inactive, and then if you guys wanted to request that it be his signature or something from him, power of attorney. Dealt with this before, whatever you think would be best to make sure it's all done correct.
Consequently, if I understand what Commissioner is, that'd be better for us to have something in the file, an affidavit or something from the respondent here saying, I'm sick, I'm in the hospital, I don't know when I'll be able to return or address the issues before us, and therefore I am requesting that my license and certification be placed in inactive state. It. Only thing he'd have to do is sign it, and even though if he is.
That's my thinking, yes. Commissioner Johnstone?
The process is just to, thank you, Mr. Chairman. The process on going inactive, and this question is for Ms. Avers, I didn't think it was that complicated. It's just pay the fee and sign the paper, isn't it?
There is an application, and it basically, I don't know word for word, but basically it says I promise not to do any work while my license is in active status, and you have just to sign and date it, but you would have to get a notary to sign it also. So I don't know, maybe they can get a notary to go down to the hospital and witness him signing it, but that usually a notary requires witnessing your signature and presence.
Does that form have a notary place on it?
Yeah, it requires it's an affidavit, it requires a notary seal.
Could his wife not just fill that out and he sign that in any of? I personally would be okay letting her sign for him if some way to, in this situation, I mean, if he can't pick a pencil up, if he can pick a pencil up, then I agree he should sign it.
I really don't know. So
I
I've
would-
gotten all, the doctor's note really only says he's been in the hospital since August 16th.
And we can't really request further.
Yeah,
medical
we're kind of
documentation.
limited by HIPAA standards to, or law, to ask about someone's medical history.
I would move that we allow his wife to fill out the appropriate application paperwork and ask that he sign it with the notary, and there's generally a notary at the hospital that can witness that. However, if he is incapacitated to the extent that he cannot physically sign it, in this one specific instance, I would be amenable to letting his wife sign that in the presence of the notary.
We have a motion from Commissioner Johnstone,
Second.
second from Commissioner Standifer. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion carries. Item number 8.
Item number 8 is 2013-018321. This complaint was filed by a consumer and alleged that respondent charged the complainant a $100 additional fee for reinspection in order to inflate complainant's fee. Subsequently, the $100 fee was refunded to the complainant. Respondent sent a response to the complaint stating that she did appraise the property owned by complainant and that her client in the transaction was a regional bank. At the time of the appraisal, there were questions concerning the roof, HVAC, and a non-working toilet. Sorry. Respondent stated it is the job of the appraiser to alert the client if there is anything that would impair the safety, structure, soundness, livability, etc. of the property. After the repairs are made, it is customary for the bank to ask the appraiser to go back out to the property to verify the repairs have been made. The cost of this final inspection is $100, which is the customary fee for this area. It is the responsibility of the bank mortgage company to let their client know the fee is involved in financing a property, referred to as a good faith estimate. The bank knows exactly what the appraiser charges. It was the bank's choice to refund the complainant's $100, and the bank paid the respondent her $100 fee. Respondent has been licensed as a certified residential appraiser for more than 15 years with no prior disciplinary action. In addition, complainant's money was refunded, and there appear to be no violations on the part of respondent. As such, council recommends the matter be closed with no further action.
Second.
I have a comment.
Okay. Well, first, we have a motion on the floor to accept council's recommendation from Commissioner Hall. We have a second from Commissioner Johnstone. And now we can have discussion. Commissioner Point.
I don't know why we're even discussing this. This is about fees. I thought it was illegal to talk about fees.
Is there, let me ask, if I may, Commissioner Point. Is there perhaps a rule or a requirement by code that we address every complaint? Does every complaint come through this process, or do you, our director, Ms. Avers, have any latitude in dismissing a complaint that comes in?
The only time a complaint wouldn't be presented to the commission is if the complainant essentially filed it with the wrong board and it belonged to another agency. In this situation, there's really nothing under the board's authority regarding fees. So that's why Ms. Baird recommended close. Since
Oh, I'm
it's-
sorry. I must not have asked it correctly. Let me rephrase the question. Do you have to process every complaint that comes in, or is it possible that this could have been not even considered and that the respondent not even bothered with this? Is that possible?
We have to process every complaint that comes in because I am not the authority to interpret the board's laws and rules on discipline. I could have been wrong, and then somebody could say, well, you just took it on yourself to not even let the board hear this matter. So we have to process everything that comes in about an appraiser or appraisal to the board.
We'll let Commissioner Johnstone go first this time, and then
No
Commissioner Hall.
problem, no problem.
Well, I think Ms. Point had a fine point there. And with that being said, I want to withdraw my second because I do think she's spot on in terms of fees. And I also think Ms. Avers is spot on in bringing it to the commission as far as that standpoint. But I think if we go with council's recommendation of closing it with no further action, then we're hereby concluding that fees are a part of this discussion. Whereas if the motion was to just dismiss, period, then we're not really getting into fees. We're saying it's outside of our. I think if we just dismissed it, then the fee discussion becomes moot. If we close it with no further action based on council's recommendation, because she has clearly said fees were refunded, she has incorporated that into her recommendation, then that gets us on slippery slope. So that's my reason for withdrawing my second.
Commissioner Hall?
I agree with what Ms. position taken by Ms. Point and Mr. Johnson also brings me up to another question. If I filed a complaint and said that an appraiser overcharged me, would we consider that also?
Processed complaints that an appraiser let my dog out of the house and my dog got run over. We've processed complaints where it was a complaint against a father that was unhappy with who his son was marrying. We've processed complaints against appraisers for wearing blue jeans out to somebody's house. All of those not being within the authority of the board. However,
Well, that's what I was wondering, and that outside our scope, I mean, why are we even considering it?
It's just really strongly frowned upon to not bring them before the commission. I mean,
Right. You're the authority to determine, dismiss
if
something,
it's
not
out,
us.
yeah, I mean, if it's outside the jurisdiction and that's what you want to do is dismiss, you can, but it's kind of put on our shoulders to process each complaint as if it were something that, even in the legal department, that's the case, so.
So what you're saying is follow Mr. Johnstone's recommendations, and rather than close, we just should dismiss this.
Well, okay, so here's my question. Does anyone have anything else?
I have one last comment before the commission votes. There has been a situation where an appraiser regarding fees took a complainant's money, and the complainant didn't get the appraisal for more than a year, and a judge ordered them to give the money back, and they still didn't do it. The commission did revoke that guy's license because it was a violation of public trust. It's exceptionally difficult for something regarding fees to rise to the level of you've violated the public trust, but there has been isolated instances where the commission had to go, whoa, that's not right, and the ethics rule preamble was cited as you violated the public trust.
Well, here's my question. I appreciate that. Thank you. Is it possible to better apply this process and this rule, and would it be possible for you to submit this type of thing to us first and let us in sanitized version, of course, so as not to compromise the hearing process, but it troubles me that the respondent had to take any time whatsoever to deal with this, and I would like it, and I'm wondering if it's possible if you could bring this to us in the legal report and ask the commission, and I defer to my fellow commissioners, but this seems to me this falls into a bucket full of frivolous complaints, much like the son-in-law and the jeans.
The complaint is always forwarded as part of standard operating procedure. The complaint itself is always forwarded to the respondent appraiser to respond if they choose to. We didn't ask in this situation for a copy of the appraisal. We didn't do a USPAP review of the appraisal because the allegation was narrowly focused to, he took my $100.
So it could be as
But-
easy as an emaal response.
Right,
then. So
they
the
could just
respondent-
say yep, or they could just disregard and not respond. The only type of response that is legally required is that work file rule, the law and the rule on if we ask for a copy of your appraisal, you have to give it to us. We ask for a copy of your work file, you have to give it to us. So that's the minimum most appraisers have to submit to a complaint. They don't actually have to respond to the complainant at all. They could just disregard and send us the thing to be reviewed.
But we are required to send it out for a response.
Yeah, it would almost be like keeping information from them if we didn't. Say, hey, somebody's complained about you, here you go. Here's your opportunity if you want to respond to it. You may, if you don't want to respond to it, please ignore us.
I mean, yeah. In this situation, if no response had been filed, it wouldn't have made a difference in the recommendation, but we have to, even if someone's dog bit someone, once the complaint's filed and it's going through our process, we're required to send it out for a response.
You wouldn't like to find out that you had been complained about and I just decided not to tell you. You're like, didn't,
Well-
I just decided not to trouble you in that somebody is saying all these things about you, that you did all these things, and I just.
figured that's how my life worked.
Right. We try
Blissful
we
ignorance.
try to do everything out in the open, so everyone is given an opportunity if they should want to respond. No, we don't keep the complaints secret from respondents.
Okay, so, well, we had a motion to accept council's recommendation, and now, and we had a second, but the second has been withdrawn. Would Commissioner Hall like to withdraw his motion?
Yes.
Okay. So, we are back to no motion and no second.
I move to dismiss matter 2013018-321.
I second.
Motion to dismiss with, would you like to say no further action?
Just no further
Dismiss.
action.
All right. And a second.
I second.
Second by Commissioner Point. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? Hearing none, motion carries. Item number 9.
Item number 9 is 2013-015-371. This complaint was filed by the administrative staff of the Tennessee Real Estate Appraiser Commission for a violation of TCA 6239-425-3, procuring a license by fraud, misrepresentation, or deceit. With submitting the initial application for Respondent Appraisal Management Company, Respondent answered no to character question number 3, which asks if the controlling person has ever been convicted of, pled guilty, or pled no contest to any criminal offense, or if there is any criminal charge now pending against the person. Subsequently, based on the information in the application, Respondent AMC license was granted on July 5th, 2013. Approximately 3 weeks after the license was granted, Respondent sent a letter to this office along with an amended application stating that it wished to amend the license application because question number 3 was not answered correctly on the previous application. At the time the application was filed, Respondent controlling person claimed she was not aware that an incident she was involved in the past resulted in a guilty plea to a charge of domestic violence. Respondent controlling person claimed she mistakenly presumed the matter had been dropped. Respondent attached a letter which more fully explained the situation. The contents of the letter suggested that a few weeks after receiving the AMC license, Respondent received a copy of the controlling person's background check, which revealed a guilty plea to a misdemeanor charge of domestic violence, resulting from an incident that occurred in July 2012 in another state. In an effort to provide full disclosure to the state of Tennessee regarding this information, on August 1st, 2013, Respondent filed an amended AMC application. Respondent stated that at no time did it attempt to procure the license by fraud, misrepresentation, or deceit. Respondent claimed that as soon as it was aware of the information, it promptly notified the state of Tennessee in good faith. Failure to disclose the information on the initial license application was purely a misunderstanding on the part of the controlling person. The recommendation is, since Respondent did make a good faith effort to notify this office of the misunderstanding regarding the record of its controlling person once the information was brought to Respondent's attention, it does not appear that Respondent was attempting to procure the license by way of fraud or deceit. Thus, it appears there was no violation of TCA 6239-425-3. As such, Council recommends the matter be closed with no further action, and Respondent's license will remain active.
Do I hear a motion?
Make a motion to accept.
Second.
Motion and a second. Motion by Commissioner Johnson, second by Commissioner Hall. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion carries. Does that conclude our legal report?
Does.
Thank you.
Thanks.
Would commissioners like a short break, or should we forge ahead and move on to the application review? Everybody seems good, okay. Let's move on to the item at 2 o'clock. It was supposed to be at 2 o'clock, but we're getting through this quick. So, Director Avers?
The matter on Mr. Gary Beaver. He had been previously presented in the July meeting, August meeting regarding his application, which had, where he had been revoked in Colorado, and he came to address that. It was recommended at that time, and the vote was approved, that the matter be given additional consideration and deferred to this month's meeting. On Friday, after all of the application and all of the agenda items had been sent to the commission, Mr. Beaver contacted my office and first verbally and then second by email sent a letter withdrawing his application. He didn't want it considered by the commission. So I recommend that this matter be closed, that his application be denied until such time as he wants it reconsidered. He'd have to reapply with a new application.
Your recommendation is that first, the application be denied?
Well,
It seems like
he
they're-
has requested it be withdrawn.
We
So in
haven't
order for-
decided on it, so I guess it's his prerogative to withdraw it.
Yeah, but it's the commission's decision to vote on it or not. I mean, it was an 11th hour request.
We really don't have a decision to make, do we? Since there is no matter before the commission any longer, is there?
Essentially, you don't even need to vote on this. He withdrew. He doesn't want the commission to vote to deny the application based on the information. He repeatedly said, if I were the commission, I'd deny me also. So I just want to withdraw. And I encouraged him to come. I encouraged him to just let it go before the commission and let the commission decide if he had any additional information. He said, no, I want to withdraw.
He notes that he'd like a refund of a portion of his fee.
It would be the $430 certification portion of it. There's a $125 application fee and a $430 credential fee. When someone applies through reciprocity, they just pay it at the same time. So although the $125 is non-refundable, the $430 can be processed for refund.
Can be.
Can be.
And what is the $430? What's the function of the fee?
$80 of it is the National Registry fee, and $350 is the state's cost for the credential for 2 years, if it's approved.
I see. So that's really the cost of the credential, the
Right.
cost of the license.
It's what everyone pays for a credential.
I
You know,
see.
your for $430 renewal fee is what you would see. But when you're initially applying, there's also a $125 application fee so they just lump it all together. One payment is fine.
Commissioners, questions? We don't require a motion on this matter, so does anyone have any other discussion? Okay. Hearing none, we'll just not vote. All right. Next item is letters to the commission.
Mr. McDonald has an appointment at 2 o'clock to speak before the commission. I wouldn't want to do it without him present because he very strenuously wanted to see the commission again. So that's the letter to the commission. His emails on the qualifying online education. He wants the commission to change the rule.
Okay, well, Commissioner Johnstone, I can tell, has a question.
Thank you, Mr. Chairman, and thank you for the astute observation skills you have out of your left peripheral.
Practice.
Is there anything in an effort to we certainly don't want to, cut into Mr. McDonald's time because he'll have ample time at 2, but is there some background on this that you could lay out now so that we don't have to hash through that at 2, which would not inhibit his ability to present his case?
All of the information is included on the iPads. If you just flip to that section, you
So
could
you
review
want us
all of
to
his
read it, not-
emails and all of his requests.
Sure.
It's essentially that he believes the not allowing online qualifying education is unfair, and specifically it's unfair to minorities.
Thank you. We'll give that its proper course, its proper time. We'll give Mr. McDonald an opportunity to talk to us again. I think that's clear enough. Let's move on to the director's report then.
Director's report is towards the back of your iPad documents. Give me just a second, I'll give you the exact page number. '92 of '94. Item 1 on the director's report is just restating that the director, the chair, and board council are scheduled to attend the ARROW meeting October 19th through 22nd. So if you have any information that you want any of us to gather from the association, or information you want us to convey on behalf of the board, this is just a reminder notice. Several applicants have recently applied to our office. This is item number 2. It's been happening throughout the summer, where the applicant took education significantly before the 2008 requirements went into effect. Now they're applying to upgrade, and the courses they took previously do not meet the current qualification requirements. The qualification requirements are now very specific as to what courses must be obtained, principles, procedures, USPAP. USPAP doesn't tend to be the problem. It usually is principles and procedures, where the schools had education approved prior to 2008, which was non-specific to the current requirements, like I listed a couple of them: foundations, appraising single-family residential, fundamentals of rural appraisal. Those were all, they were approved prior to 2008 as qualifying education. They are not currently approved under the matrix requirements because they're not specific to it. There's other education too, like a URAR course, or there was just a bunch of them that were approved generically as qualifying education because before you just had to meet a certain number of hours of qualifying education. For license, it was 90 hours. For certified residential, it was 120 hours. And for certified general, it was 180. But January 1st, 2008, the new requirements went into effect. And if you didn't have the requirements met before 2008, you have to meet the new requirements, which are the kind of the specific recipe of courses, along with for certified residential and certified general college education requirements. It's been coming up more and more frequently, and I expect it will come up a lot more as we approach 2015. We'll get more and more applicants who thought they were somehow grandfathered because they were registered trainee prior to 2008, but that doesn't waive the requirements at the time you apply to upgrade a license. In 2015, the segmented approach to education will go away. Currently, if someone can demonstrate they had the requirements met before 2008, the requirements, it's in the rules. If they met it before 2008, then they can be considered under that education requirement or that experience requirement. The experience requirements didn't change significantly, but the education did. And the exam, nobody could go back and take the old exam after January 1st, 2008. So that one also isn't a significant feedback from the licensees. But the education, clearly there are more than one applicant that's had issues, and some of them are going back and requesting the commission approve a course that the education providers never submitted for qualifying education after 2008, such as the one for this afternoon, which is a procedures course that the University of Memphis didn't submit as qualifying education after 2008. It's going to be, I think this is going to happen and happen and happen. We're going to get more trainees applying, trying to use a hybrid of the old education and the new education, which is a problem.
Is it primarily the matrix requirement? And and let's be clear. This is an AQB mandate. This is not optional. It's mandatory by the feds. So this is a done deal. And is it the matrix then and the information, the materials that they're having problems with? Is that what you're telling us?
It's certainly difficult for a trainee or a licensed appraiser, whatever it may be, to do what we require an education provider who's experienced in submitting education on this matrix form. We have to make them do exactly what the course providers would do. And so what would be very easy for the education director at Appraisal Institute is really hard for somebody to fill out on their own, especially if it was an old course. They may not have maintained the materials. You know, I took this class in 2002. I don't have that book anymore. The school doesn't offer anymore. One of the schools stopped offering appraisal education entirely, but we still see information from them occasionally. CLI closed its appraisal business. So they don't offer appraisal courses anymore, just real estate courses. So there's not even anyone on staff to answer an applicant's question. It's very, very difficult, and we have been exceptionally accommodating to any licensee who has had that problem, showing them other examples of the matrix properly filled out, giving them essentially other person's application to cheat off of, like this is what an approved one looked like, make it happen for your course. But we don't really have anything in our laws or rules that allows for an individual course approval for qualifying education. It specifically says continuing education, and we've just been allowing the applicants for qualifying education to piggyback on that for $25. I don't think it will be too much longer before we lose Dr. Barilla as the education member, as his term technically expired in June, and the governor has not yet appointed somebody to serve his position. I can't imagine the governor's office taking too much longer. It does say in the statute, everyone shall serve until the governor appoints somebody new, but I don't know how much longer Dr. Barilla, after 6.5 years, is going to want to continue to do our education review. And I certainly don't think the rules applicable today are adequate to address this. I think it's a lot of work on staff's part for almost no application fee. And
Are you advocating that we need to entertain a rule to address this issue?
I think it's something we need to address and when we do a rule change. We're scheduled for rulemaking really anyway, so I think this should be incorporated as part of it, that, you know, it can go on for as long as it can go on, but at some point we needed to address this specifically as to qualifying education and what the applicants will do. I think it's bad policy to keep piggybacking on a rule that doesn't exist for qualifying.
That's, and has the AQB offered this is their rule, have they offered any guidance to the states as to how we're supposed to navigate our citizens through this matrix?
Not really. I mean, the matrix is the matrix, and it's outlined in detail in the criteria, but for an individual applicant, it is a gigantic task to, I mean, it requires some detailed information to go through the matrix and say, this section of the matrix was covered by these chapters, and this section was covered by these chapters, and I answered these exam questions. The matrix is fairly specific.
But do you know what the AQB, and I don't want to belabor this, I'm sure this is, everybody wants to think about this a lot, but do you know why the AQB made this rule change? Were they specifically trying to make QE no longer applicable and difficult to get?
Well, they tried to increase the appraisal requirements, the qualifying criteria, to improve the profession so that new applicants have a specific and everyone has essential core education for each of the 3 credentials. So there's progressively more education required for each of the credentials. The same thing with the experience and the examination. The examination today is between a 3 and 8 hour exam. The previous exam, people usually took it within an hour, hour and a half. It's a difficult test, incorporating experience. It's a practice-based exam.
Oh, a question then. We're going to take up some rule changes when, approximately?
I have to write them first, but it would be helpful on the front side to know what the commission is heading towards on these topics, so that when Keeling drafts the rule changes, you know, she doesn't have to do it. We have a rulemaking hearing, and that isn't what the commission voted on. You know, we didn't want to incorporate that. So if there's some significant changes, we kind of need to know the will of the commission before we draft the rule.
Okay.
I think we should have on the rulemaking hearing again, the continuing education online. I think it's the way of the world.
Let's take that up in just a second.
Okay, sorry.
No, I appreciate that, because I didn't see it on the director's report, and I want to talk about that too.
I'd like to make a comment on these lines. Obviously, we've got kind of a broken system here that we're trying to cobble something together to get through for a temporary period. But you're the one dealing with the mess, and you're the one that understands the components. What are your recommendations? Should we make a temporary avenue, an alleyway, so to speak, for handling this education? Make a new set of rules for these specific that would abbreviate some of the matrix requirements?
We can always provide the matrix requirements to any applicant. It's just that they're having a hard time understanding it. Specifically, we need to address in the rules what the application process would be. Instead of saying, just like if you're trying to visualize, the law grants the commission authority to do certain things, including education, approval of education, and that kind of stuff. The rules outline more specifically how that's going to be applied. Like it kind of outlines what I have to check on an application. So just in that same venue, there should be a rule that addresses individual review of qualifying education and what that should look like for approval. I attached a copy of the continuing education rule, and as you can see, it's very skeletal. It's so at the bottom.
At this Tennessee code in italics?
Yeah, 1255-214, that's all it says currently. And if you were an applicant and that's all you had to go on so far as the commission's rules on what you have to submit, $25, and the provider information.
Says the proper form.
Right. There is no form for qualifying education.
I hear you
This
saying.
is the only relevant rule.
To Commissioner Walton's question, I hear you saying there is no alleyway, there is no streamlining. We need a formal rule, and it needs to lay out the application process, what that content will be, what fees are required.
Yeah, it needs to be addressed specifically when we do rule-making hearing. I think this has just been something that it's been allowed to progress for many, many years, and letting people apply for qualifying education the same way they do with continuing education, but it's sort of a gap in our rules.
It's within our purview as a commission to lay out a pathway that would be simplified for individuals where they wouldn't have to meet the same requirements as the Appraisal Institute or any of these other educational organizations, or would you recommend something else?
They have to basically submit the same information that a course provider would submit. We don't require them currently to submit the entire book, but just a snapshot or the course summary with it. We would require a school to submit the actual materials.
We, maybe, I think Commissioner Walton's question, I'm wondering if it might be, we can't diminish the AQB's requirements. We have to have the matrix. We have to have the syllabus, et
Right.
cetera.
And we're going down, we're getting down to 0 hour. We're less than, we're a year from those implementation requirements. And after 2015, nobody's going to get through without having met the matrix requirements. There's not going to be anyone who gets to apply under the old rules at all. So if the course wasn't approved by the provider, they're going to have to do it themselves after 2015 because the segmented approach is gone.
We need this process regardless. I hear you saying.
We're going to
Basically.
need it outlined, and it really should be more formalized. For future education directors or education committee, and also for the director and their staff to know what is the minimum requirements.
Good. Commissioner Johnstone.
Thank you, Mr. Chairman. Just for clarification in my mind, the pathway that Commissioner Walton's talking about is for qualifying education or continuing education?
Well, I think, didn't you say there is a continuing education?
There is a path now,
Pathway
and
there.
that's what's italicized at the bottom of the director's
Right.
report.
Right.
And I've actually used that in the past where I've submitted the application fee and the course curriculum. Now, I did not go through the matrix process because it was prior to '08. And it was fairly simple to do at that point in time.
Right.
And it may be more difficult now, but I don't want to get the two qualifying education online mixed up with continuing education online.
Right.
Because we have that path available right now. It may be more difficult than it was previously, but that is an option today.
Well, let's be clear. You use the word online. We're not making any distinction about online at this point. We're simply talking about QE and how you get old QE brought in and allowed for your application.
You're talking about QE, or are we talking
Qualifying
about
education.
We're talking about QE.
I know, but my understanding is
That was only included for reference.
2.14 is for CE only.
That's
CE
correct.
And that CE could be online or classroom, either way. If it's,
Continuing education, the commission allows up to 14 hours to be taken online. There isn't any allowance for qualifying education.
Yes.
I'm unclear as to what path we're on here with all this.
We're discussing how, for the trainees that were registered prior to 2008, making some sort of allowance for them to bring their old education, their pre-2008 qualifying education forward under the new standards and have some way of them meeting the new standards.
Some of the courses, if the providers had submitted them, would have met the requirements of qualifying education, and Dr. Brill has certainly reviewed several. But individual is only individual approval. So, like, if somebody else submitted that exact same procedures course that a previous applicant, it's still not an approved course. Individual is only for the individual.
Commissioner Johnstone?
Director Avers, how many applicants do you foresee this? Plus or minus 10, plus or minus 100?
We have, I think, 240 trainees currently.
No more than 240, worst case.
Yeah.
Those are
254, excuse me,
registered, right.
254.
Those are just the registered ones.
That's just the registered trainees, and that's not taking into account any of the people who are licensed or certified residential that may want to upgrade to certified general or certified residential. Same requirements. I mean, if they have to meet the requirements to upgrade.
Do they have to provide the matrix seems to be the kicker here. Say Dr. Barilla has gone through a particular class. He's went through that with John Smith and says, okay, that's good. I'm okay with this class. John Smith, you have the option to put that class on an Excel spreadsheet so he doesn't have to review the matrix the next time that class pops up. And then and the staff, when they see that, they go, well, he's already approved that one for John Smith earlier. We know it meets the criteria, and you can check that box to help facilitate the process. And if you're talking about maybe 30 or 40, that's a lot of work on him, but it's a lot of work on me reading 300 pages of appraisal reports for one trainee today. So there may be a path there already that doesn't require a lot of changing in rules from the commission. That's my point.
Well, I think that at least this particular rule would need to incorporate the language saying he's allowed to, on an individual basis, review qualifying education. There's currently nothing that says individuals can submit qualifying education. No rule. Zero.
That takes.
But we still do it. We just pop it under this rule.
Understand, and if I can continue, Mr. Chairman. Absolutely. The process and time it takes to get a rule change implemented and voted on, it's not something that can be done overnight. So you're talking about a process and a matter of time to even get us to the point where he could review individual qualifying education.
I'm just trying to put it on the pathway to having a rule that covers
Right.
this.
So-
We're certainly allowing other applicants to view the work of others. We give copies of prior applications, but they still have to do it.
Now, when did the rule changes that we have to vote on? Is that 214?
We haven't submitted a draft to the commission yet because the law hasn't passed on the fingerprint background check yet. It's been proposed.
Now,
It's hopefully going to make it into this legislative session, but
now
all the
we've-
rules are going to
we-
be at the same time.
Now, I remember us bringing that up a while back, whereas if it's a renewal, that fingerprinting is not going to be required. It's only for new applicants.
That's how it's been proposed. The legislative body,
Right.
of course, can be unpredictable, so I'm not speaking on their behalf.
So, but that hasn't been voted on. Can we add this particular rule to that package that's already been presented to the legislature?
It doesn't need to go into legislator because the commission already has authority to make rules on qualifying and continuing education. So that just needs to be
So
part
then
of
that
it.
process could be streamlined. I was under the assumption
Right.
that had to go to the legislature. So we could vote on that today to make a streamlined path for Dr. Barilla to do that on qualifying education.
Could vote on a new rule, and then the rule would have to go through rulemaking hearing, but it's within the commission as opposed to
And
having to go up the
rulemaking
hill and
and
back.
rulemaking hearing takes how long and how many readings?
Well, we have to write it, and last time it was 44 pages of
I think we could
rules.
do it in a paragraph or two.
Yeah, but we're going to do everything at the same time because you don't want to do one.
Other rules that will.
Well, that was my point. Can we not just do this one rule as an amendment to the existing rules to get us over this hump, which we know is coming?
I think the rulemaking here is going to have to happen all at the same time, but I just want to make sure that this is incorporated. And certainly, to Ms. Point's,
Would this not speak to Mr.
Discussion.
McDonald's issues that he's going to have later this afternoon?
it is going to, yeah, I mean, certainly we're affording him every opportunity to apply for individual course approval for qualifying education, but
I just in my mind foresee rules making hearing in the voting on that. I don't know if it's one or two readings. I just cannot fathom that happening before sometime in 214.
yeah, no, it's going to be at least
And
mid-
these issues are going to be coming up before that. So if there was an option, and if legal could maybe look into that to see, could you amend the existing rules for one issue that you know is going to be very problematic, such as this, it might help a lot of folks.
I don't think it would make it go any faster, but I just wanted to discuss this and discuss whether or not online education should be allowed for qualifying education also, so that when Ms. Baird drafts rules and we have rulemaking hearing, hopefully summer 2014, everything's incorporated all at the same time and we don't miss anything.
Let me interject here. Maybe it would be possible. There are other issues that we're going to deal with in that rulemaking session, correct?
Yes.
Okay. All right. Is it the commission's favor, and we'll talk about online QE here next, but let's first deal with the matrix issue. Is it the commission's favor to request the director and our legal counsel to draft a proposed set of rules dealing with the matrix issue and the QE issue, and how the application process? I mean, I could see the commission directing our director to come up with a draft set of rules for both this issue and for the online. So, you know, I think we need to ask or consider asking for that draft rule. Sir.
Mr. Chairman, I think if I understand the Director Avers, and she can speak if I misspeak for her. Now, my understanding was she would like some guidance from us on what we think direction we want to drive the bus before they sit down and write all these rules. If we want to go all CE online and all QE online, we need to give them some direction. Otherwise, she may just say, well, I can look at these 40 states that are doing it this way, and I think it ought to be this way, and they spend 2 weeks drafting these rules, and they come in, and then Mark looks at it and goes, I don't like that.
Well, I'm saying let's deal with this in two stages.
Right.
First, the matrix and the AQB standards, and that I see that as one set of rules and one application, and then and if there are further comments from other commissioners about that issue, but you know, even to the point where it might be good if someone made the motion, look, we direct Director Avers to provide a draft set of rules that complies with AQB standards and deals with QE that has expired. Nothing to do with online, just QE that's been expired, okay. And you know, to go through the matrix process. Is there a motion to that effect, or is there more conversation and discussion?
I'll make that motion. I would say that, are there any other states out there that's already dealt with this issue that could provide? It's going to be at Arrow and could certainly have the resources at hand to identify some model states to
Excellent motion.
I'll second that.
Okay. Motion from Commissioner Johnstone, second from Commissioner Collinsworth. Further discussion? Hearing none. All those in favor say aye.
Aye.
Aye. Any opposed? None opposed. Okay. Director Avers, you brought up the topic of online qualifying education.
It's been considered by the commission previously, the online education, and it was actually drafted, at least in part, by Dr. Barilla. It was presented to the commission, and then we had a rulemaking hearing in January of 2012. And the only response at that time on that rulemaking hearing was from people opposing it. Specifically, one of the education providers had a substantial showing at the last rulemaking hearing opposing online education. We have since received a lot of letters from trainees, and we certainly get phone calls all the time saying, why can't I take my QE online? The certified general courses aren't even offered in Tennessee. We get a lot of requests, and a lot of the surrounding states offer online QE. So we're allowing reciprocal applicants who have taken their education online to gain a credential in Tennessee, whereas the residents have to take all of their classes in classroom or they won't be approved. It's coming up again. I think there actually was a lot more support for it than was voiced at the last rulemaking hearing. I think it was presupposed by many of the trainees that it would get approved, and it didn't get approved. The commission voted it down.
Couple of questions regarding online. What is the technical term for interactive online? There's some, do you remember that term? I'm sorry to put you on the spot. What is it?
There's webinars, and there are a brain lock. We get these applications occasionally. What do you?
Basically, they call them webinars with audio and video, where it's conducted at a specific time, and you log in and you sort of listen along, or you actually see along if you have video capabilities.
Well, and there's the accountability is there also. And isn't there a national, there's a national oversight of online QE, is there not?
There is. It's called IDEC approval.
That's
and that reviews the matrix, or excuse me, the matrix. Getting that stuck in my head now. IDEC reviews the mechanism for course delivery specifically and makes sure that that meets minimum requirements. So you couldn't just take a correspondence course, have an open book test, and pass it. That's not allowed by IDEC approval for appraisal courses. There has to be a proctored exam. There has to be a mechanism for the students to have interaction with the course instructor and respond to certain things, and that's required in the delivery mechanism in IDEC approval. IDEC only reviews the delivery mechanism for online courses, but every course has to get IDEC approval for it to be approved in any state.
This is an informal question for the commission. Okay, I would like to take an informal poll of our commissioners. Is there any commissioner here that would have a problem approving an IDEC-approved QE online curriculum? I can restate that again. Is there any commissioner that would have a problem approving QE online as long as it's IDEC approved?
Yes. Possibly.
Yes, possibly. We'll talk, and then
I
Go
would
ahead.
like to find out if we could get some sort of a list or summary of what those qualifications are before we could really answer your question. Because I mean, it comes down to what the standards are as to what your level of attendance is before it can be approved, before I would approve it. If it's a webinar where you have to be present in that type of a situation, I'd be more open to approving that versus if it's one of these situations like a continuing education where you can come and go as you please.
newspaper perhaps.
Right. I would think that I'd like to see what the requirements are before IDEC would approve it.
Director Avers, can you supply us those IDEC criteria?
I think so, but I know just based on my knowledge and experience with the course approvals, IDEC courses have a requirement that the information be tested before you move through each chapter. And in qualifying education, an additional requirement is that a proctored exam be provided. It's not, you can't take the test online and just sit at home. You actually have to take a proctored exam for qualifying education. So if you did not review all the course materials, or it wasn't you that took the class. You know, all of those concerns that people had with prior qualifying education. You have to, just like you would for the national exam, check in with an approved course proctor, sit in front of them and take the test. If you didn't do the material, it's going to be really hard for you to pass that test for that qualifying education. It's not like what many may have experienced in real estate courses or home inspection courses or prior, where you could have the materials shipped to you and you could just review it in your own time and then take the test and mail it back to them. That is not an approved IDEC course. IDEC would not approve that as a delivery mechanism.
Have a problem with it. Talk to us about your concerns.
My concern comes from having people take these courses without having the interaction of the instructor or the other appraisers. When they get through, they go by the book technically, and they are correct. Unfortunately, without the additional knowledge that they can pick up in that class, they really, in my opinion, do not have the education necessary to be turned loose on the public. I am just very concerned that the education that they get from a book, an exam, does not broaden their knowledge enough to meet the public demand. The book tells me that I need to have sales that I can abstract my adjustments, and that's good, except the market doesn't operate that way sometimes, and I'm concerned about how they're going to be taught what do you do when that doesn't happen, when you cannot find the data. Are they being taught what to do next or what the next level? And I'm concerned that they only are getting this stuff from a book. They're not getting the full knowledge that they could be getting from actually in a classroom setting. I am just very concerned about that. I reckon this comes from having people work with me over the last 50 years, and I have seen that they've got a tremendous amount of book knowledge, much more than I've got. But when it comes down to practical application, all of a sudden, they don't have a clue. And the only way they get that is by attending classes where they can interact with other people and find out what is going on and how to handle these specific situations. We'll go back to what we just saw as far as one of our matters we reviewed today. This was a rural area. You're not going to have the data. Yet, according to this published matrix over here, or published data, USPAP, you can't do that because this is what it says. There's no practical application. And I'm just concerned that the appraisers that are coming out, if you give them an income statement, they'll probably be able to sit down and work that income statement better than I could. But they still won't know what the value of the property is when they get through because they do not have that practical application. Maybe I'm confusing experience with education, but to me it's difficult to separate the two. So I do have a problem. Maybe I just don't know enough about this situation, about the IDEX or whatever like that, but I just have a real problem when the only education they're getting is out of a textbook. There's no way a textbook can teach them everything they need to know, and no way you can be taught everything you need to know. I'm still learning, and I've been doing this a long time. I learn something new every day. So I'm not trying to imply that when somebody comes out, they're going to know everything there is to know. We all learn. If you ever stop learning, you're dead. So consequently, I'm not trying to imply that they're going to have to know everything there is, but if the only thing they got is a textbook application, then they're not going to be able to apply that talent out here in the real world.
I understand your point, and I do think interaction is very good, but that is essentially why the Appraisal Qualification Board set an experience requirement for each credential level, minimum 2 years for licensed and certified residential and 30 months for certified general, and that the supervisor has responsibility for that experience component with the trainee. And we even have additional rules in our requirements that a supervisor shall give this instruction on these specific requirements. If you look under 1255-1, at the end of that rule is the supervisor's responsibility to provide that experience component for specific. The test, the national exam, is now a practice-based test. So if they don't know how to do it, they aren't going to pass the test. You
Well-
can't simply memorize from a book and then pass that test. You have to know how to apply what you learned. Without the experience, you won't pass it.
Isn't it, well, two things. Isn't it also the case, beginning 2015, supervisors will have to have a credential, and they will have to take a class, and you'll have to have a supervisory credential in which, so they're kind of splitting that function up, I think, Commissioner Hall. I think a really nice viewpoint to address your concerns would be from a highly experienced Commissioner Point, because she too has decades of experience, and I know she recently had an interactive online experience, I think. Have you not?
I've taken several interactive classes. I've never submitted them for credit, but they're really good because you get comments from people all over the countryside. And if you've got the webcam on your computer, you can instructor the whole time and everything they say and all the graphs they put up online, and you can hear all the comments the other people are making, and you can comment. You just have to have your little program set up and test it out in advance and be sure it's all working and get your webcam up and going. And
Feel like it was any, you think it was any less enriching having that interaction from other appraisers online versus over coffee?
I thought it was very good. I was very pleased. I was, for the first one I took was maybe 3 or 4 years ago, and I was shocked. But I mean, they're even getting better as it goes along. I've never used it for credit. Some of them I got credit for, but I've never submitted it. But I was very impressed what you can do online.
I've found that to be the case too. But would anyone else like to comment?
I had a question, but if
Please.
it's in reference to the examination portion, and it's simple. They go to like a testing center like you would for your regular. In there, I mean, who proctors this? And if part of the push for going to proctored exam site is in Jackson or Columbia, you'll have to travel. I mean, where are the proctored tests are, and can those be done in your hometown with? What's the process on the testing?
The exam proctor would have to be an approved exam proctor, and the course providers would have to submit them for consideration. Again, previously, Dr. Brill outlined some online education requirements for approving those proctors in the prior rulemaking hearing in January of 2012. And they were very specific, and that's currently, from the discussion that was had, why the prior commission members felt it was inappropriate to approve them, but with that one component added to it, with the proctor being approved.
I'm still confused. Is the proctor, I mean, where are you going to just pull a proctor out of the air that meets the matrix criteria in Wayne County. I don't understand how you, I mean, if there's only a handful of proctors that's been approved, then I'm gonna have to travel to Johnson City or to Memphis to where the proctor is, or do you go? I don't understand this proctor process.
Specifically, if it was approved, the school could designate any college or university to offer it, where if they offer online courses, they could just be sent the exam and proctor the test on their behalf. The current exam provider, PSI, could also be another opportunity. They could submit Sylvan Learning Center, they could submit,
So it's incumbent upon the online provider to identify 42 venues within the state of Tennessee and send them to Dr. Barillo.
and proctor, yeah, the proctors would have to be approved. It could be a universal approval where, if they could designate it anyone who takes a course at or exam at
That's
PSI,
fine.
but
Yeah,
we have to have some enforcement authority over the proctor. So if they abused the rules, their approval would be revoked.
Commissioner Hall?
5 different providers with qualifying education. Is there a standard exam for all 5 of those proctors?
The exam it would be specific to the school and the course, but who can watch someone take the test and retransmit the information back to the school to check? That just has to be identified as an approved proctor. So they could designate University of Memphis, or they could designate all PSI, or they could designate, someone who would have consequences as a proctor.
Is, if I were to develop a school for qualifying education that I taught over this webinar, Michael Green here set up one that he could present. Would we have the same exam that the students would be taking, or would they be an exam prepared by me, by Mr. Green, or whomever the case may be? Is there any, who approves the exam to be taken at these?
The exam would be considered per school, per course, in conjunction with the other education that is reviewed. When anyone submits any course for continuing or qualifying education currently, the exam is part of the materials that Dr. Brillo looks at and approves if there is an exam. It's per school, per course. Now, some schools use the same materials, such as several schools use Appraisal Institute materials, several schools use Hondros materials. Those materials would be the same if they got a secondary course provider approval to use it, like Trees and McKissick use Hondros, I think, if I'm remembering correctly. But Appraisal Institute's pretty proprietary about their course materials, and they very seldom let anyone other than the Appraisal Institute or a college or university use their materials.
I was just curious as to what control would there be over the exams that were being given?
Let Ms. Point.
I have a comment here. Why don't we let Mr. Green find out when he goes to the Aero conference this weekend what they do? We're one of 10 states that do not have the approved continuing education online. I mean, you can take all these courses through the Appraisal Institute online. It's the way of the times.
Well, and it's actually, I talked to some folks in Austin in the spring at that Aero conference, and that conference, I sat in on an education session, and that really changed my opinion. I voted against online QE last time we talked about it. I got my education 100% through Classroom Institute training. And I was a big advocate for just the points that Commissioner Hall made. But I'm convinced now that technology has advanced and there are enough checks and balances both on the exam process and the attendance process and the content process. I can share with you during this seminar, the education providers were bemoaning IDEC's approvals. They were really crying because IDEC really runs them through a grinder. So I'm convinced that it's gonna go. It's happening, and I suspect that the feds will mandate it fairly soon. It's just my suspicion. But I personally would like to see that, and this is my personal opinion, and I'm going to allow the commission to express its favor, but I would like to see the rules dealing with online QE, dusted off, brought up to speed, including the IDEC standard, and resubmitted to the commission for review as early as December, so that we can, by that time, we'll be back from Arrow, and we could have a proposed set of rules for both the matrix, the QE matrix AQB issue being number one, and then a second set of rules dealing with online QE. That's my personal opinion. Commissioner Johnstone?
Is this going to also include online CE?
Online CE is already,
I mean, from where it's from 14 hours to 28. Option of in or out of class. Is that going to be a part? I mean, if you're going to go all in, go all in.
you lost me because I'm not
saying do it or don't do it.
I'm not
just
familiar
saying
with what you're referring to, so
You have
please.
to have 28 hours of continuing education every renewal cycle, of which 14 hours can be acquired online and 14 hours must. So if we're going to allow 100% of qualifying education to be handled online, would it not be reasonable to go on and if we're allowing 14 hours, push that all the way up to 28 hours? Because many states let you take all of the continuing education online.
All right, so that's a third issue.
I mean, it's part of this whole discussion, though.
I don't disagree.
That's
What's
all.
your opinion?
The jury's still out now. I want to see it all. I'm not saying, I mean, I'm kind of like you, but I haven't been exposed to it as much to get comfortable yet.
We could try within the next several months to see if one of the exam providers that regularly presents qualifying education online or continuing education online could attend a commission meeting and talk more about it, how it's applied in other states, just to bring the full commission. We did this once before. A person came from Cengage and a person came from Columbia Institute to talk about it. But that was 6 years ago, so I don't think anyone on the commission probably remembers that discussion.
You know what I'd rather-
We invited them
I don't-
to here, and they came.
I don't mean to interrupt you, I'm sorry. I think it would be more informative to have perhaps someone from IDEC, if that's at all possible. I don't know if we have anyone regionally, or even,
I don't know.
okay.
I mean, I could try. It couldn't hurt to try, but the answer might be no.
No. Commissioner Hall.
Thank you. The fellow would still have to approve the CE courses, correct? As far as content was concerned before it could be put on the internet, correct?
The content of the course and the delivery mechanism are always reviewed separately, but the approval is made as a whole. So Dr. Barilla or the Appraisal Qualification Board, the AQB has some courses that they review, and the commission's already opined that if it's AQB approved, it's already been sufficiently, the course materials have already sufficiently been reviewed. So that would be universal approval. But the online mechanism is also part of that too. So if they don't submit an IDEC certificate, and it is important to know that IDEC approval is only good for 2 years. So even if you got the course approved, the school got the course approved, they still have to go through the mill, as Mr. Green said, every 2 years.
Okay, so consequently, what I'm wondering about is how will the appraisers out here in the field know which courses are?
We have an approved course listing that's posted on our website 24 hours a day, 7 days a week. All of the online courses start with the words online, so it cannot be confused with any of the in-classroom. Every online course has online, whatever the rest of the course name is. It is on the website, it's posted. We already have more than 350 approved courses, and a lot of them are online courses for continuing education, none for qualifying.
Let's wrap this up if we can and move on. Is it the commission's favor that we look at some draft rules, or would you prefer to defer this into 2014?
I would move that we ask the director to pull out the previous draft. She mentioned she had started a draft regarding online qualifying education. Pull that back out, add some additional information, at least that summarizes the IDEC qualifications, and then present that at the next meeting, I believe in December. That will give both of you an opportunity to go to the Arrow meeting, come back with some more information on that, and then we can look at that discussion or discuss that draft at that time.
Thank you.
If I could, I'd like to make a comment as well.
Let's hold the comment just a second. There's a motion on the table to have a draft set of rules submitted for our December meeting because there is no November meeting scheduled. So it would be the December meeting, and that's the motion made by Commissioner Collinsworth. Do I have a second?
Second.
I have a second from Commissioner Walton. Now, discussion.
Just, to put in light that it's really important that we work our way through this rapidly, because the rule changes will need to be submitted to the legislature, and they'll be in session beginning in January.
Rules don't go to legislature, they go to the Attorney General's office for review to make sure that you had authority to make those rules, and then they go to the Secretary of State's office and for a 90-day exposure, and then it becomes rule. The Attorney General's office part can be really lengthy.
Yes, it can be very time consuming.
So
Now,
we first pass it, then it goes through those two other channels,
The
correct?
rulemaking hearing that was held in January of 2012, those rules have been in the Attorney General's office since a short time thereafter, and multiple correspondence between legal counsel and the Attorney General to get those rules. They still haven't been adopted from January of 2012.
And I mean, that's not to say that's going to happen every single time, but it does take a while. I'm hoping this is not going to be a common problem.
Where do we cross the line into legislature?
When the law gives you the authority to do specific things. And the reason the fingerprint background check had to go through legislation is because the commission doesn't currently have any authority in the law to do that. You can't create rules that don't go back to a specific law. Like the law says that the commission has the authority to set qualification, education requirements, and experience requirements. It's pretty specific. I mean, you can flip through it on your iPad and see what the law grants authority. The rules just break it down more specifically to what that authority is. So the rulemaking doesn't have to go to legislator for the legislators.
As long
for
as there's
approval.
already a legislative basis for any rule we make, it doesn't have to go through.
Yes.
Okay. So that'd be a moot point.
Commissioner Point? No comment. All right, we have a motion and a second. Is there any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Okay. I was wondering, is there more director's report? It appears to be minor.
The rest of it is just informational that I present every time, where the current budget information is, the number of licensees, and the number of complaints total. So that's just standard information I present to the commission every time.
So, so we will break for lunch, and then we will have our experience. We have 3 experience reviews, if I'm not mistaken. Is that correct?
Yes. Mr. Johnstone, Mr. Collinsworth, and Mr. Green each have an experience interview at 1 o'clock. Everybody else can take a break until 2.
Okay, well, and I urge Mr. Collinsworth and Mr. Johnstone to join me in trying to get our experience interviews started earlier, if at all possible. And that way, we can re-adjourn. Reconvene, sorry, I couldn't think of the word. And we can reconvene earlier than 2 if possible. So, all right, we stand adjourned for lunch.
What time should we reconvene for the,
It's scheduled for 2, man.
yeah, I'm saying, if we all come back at 1:45.
Just stuff in football. We're going to Knoxville every chance we get.
This will reconvene the meeting, the October 14th, 2013 meeting of the Tennessee Real Estate Appraiser Commission. This is our afternoon session. It's now 2 o'clock, and the next item on the agenda is the report of experience interviews. There were 3 experience interviews done, completed. If you'll bear with me, I'll find those. Perhaps I'll turn the meeting over to Miss Avers because she may have a list of those. Dennis, do you have a list of the?
There's 3 trainees interviewed, 3 applicants interviewed. Ben Sellers was interviewed by Mr. Johnstone, and he was applying to go from trainee to certified general. Steve Carey Gregory is a licensed appraiser, and he was applying to go to certified residential, and he was interviewed by Mr. Collinsworth. And then we had one 500-hour experience review, which requires no vote. That was a George Wesley Thomas that Mr. Green interviewed.
Thank you. Thank you. Commissioner Johnstone, do you have a report for us?
Yes, I'm right. Would it be, if it's the chairman's pleasure, to go to the next trainee and let me get my recommendation clearly written?
Your request is approved.
Thank you.
Yeah.
Commissioner Collinsworth?
Yes, I interviewed Steve Carey Gregory today. As mentioned, he was wanting to move from a license to a certified residential. After the interview and the discussion we had, I move that Mr. Gregory turn in 3 more additional appraisal reports for review at his leisure with an effective date anytime after October 15th, 2013. And once he's turned those 3 in, then we will have a second interview with him and at that point decide to go forward.
All right, so we have a motion on the floor for 3 additional reports. Do I hear a second?
Second.
Second from Commissioner Hall. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? Motion carries. I can go next, give Mr. Johnstone some more time. I interviewed George Wesley Thomas, and Mr. Thomas should be commended for the fact that this was basically a status check to see where he stands on his review, his experience review, and his progression as an appraiser. I didn't find any problems with his reports. I thought that he and his mentors were doing an excellent job. There were a few minor things, but they certainly weren't USPAP related. So I think he's on the right track, and I think it's important we encourage all trainees to take that opportunity whenever they can. So. Prepared yet?
Yes. One question for council. Are these committee reports, or are these, and if it's a committee report and a committee recommendation, from a point of order standpoint, would another commissioner need to make a motion for approval and have a second? Or because it's a committee recommendation, as if I'm the one-person committee, you don't need a motion and a second?
It is recommended that the experience, the member who conducts the interview make a recommendation, and that someone else make a motion and second. But certainly the commission has the ability to
I just didn't know.
modify Robert's rules on that.
Okay, I didn't know if you would want me to make the motion, or would it be better for me to make a recommendation and let the body make a motion?
I would prefer you make a recommendation.
I had the task of interviewing Mr. Sellers. He is requesting to go from trainee to certified general. And my recommendation upon the review is for approval, subject to review and approval of some supplemental requested information to be provided to me electronically. If in the event the supplemental data is acceptable, I'll convey final approval to the director, thereby keeping Mr. Sellers from having to make another trip back to Nashville. That's my recommendation.
Make a motion that we accept.
Second.
Okay. So we have a motion to accept Commissioner Johnstone's recommendation.
And a little background, there was a couple of areas on one report that I wanted some further clarification on. And Mr. Standiford was kind enough to sit in on the review, and I don't want to speak for him, but we felt that it was a reasonable request.
I did not review the reports, but based on what I saw in the meeting, that I think that it was a reasonable request, and I think it's a good procedure to follow, and in this particular case.
Further discussion? Hearing none. All those in favor of the motion say aye.
Aye.
Any opposed? Unopposed, motion carries. All right, that concludes our experience interview report. Final item on the agenda is regarding a letter to the commission from a Mr. Glenn McDonald.
Up at the table in front of one of the microphones.
Afternoon, Mr. McDonald.
Oh, hello again.
And this is regarding online qualifying education.
Yes.
I would, Mr. McDonald, it's now 2:15. We've been here most of the day. I would ask you to, we want to give you a full opportunity to convey
brief.
what's on your mind.
I'll be brief.
How long do you think it'll take, roughly?
5 minutes.
5 minutes. All right. We'll give you 15.
15. All right.
All right.
Basically, just after asking around the foundation, several schools, about why we don't have online education, basically the response was basically the same. Everyone said, that's a good question. There are still a few states out there that do not accept the nationally approved mandated online curriculum. It would be very nice if Tennessee and other remaining states adopted the same requirements. Unfortunately, this is ultimately up to the state boards for decision. So I still didn't get a clear answer why it wasn't approved. And only thing I'm asking for is, I know I don't want to go through the whole points. I know you guys have the email about the benefits of CE, because I'm sure a lot of you use CE online. It's a benefit. I'm not asking to abolish, online class. I mean, in classroom classes, just to make it an option for some people. It's not the same for everybody. I know some people think networking, this, that, and other, but it's not the same for everybody. And as numerous reasons why that, I don't want to go through the whole thing, but I just think that you get a better outcome of a student if they can learn online and in the class, depending on how they choose to learn. Some people do better in the classroom. I've taken classes, the appraisal classes, several of the report writing and other classes from Mississippi and Arkansas. I can tell you, those classes, I learned more online than I did in the classroom. Simply being different people learn differently. It's a crash course to get all that information in 4 days. They tell you that when you first hit the door. You're trying to stuff down all that information for 8 hours, and some people can do it. Some people have to take the class more than once. I've noticed that in the class. There are people in there several times. It's no need for that. It's wasting time. If some people can look online, learn, take a break, retain the information, go back, look at the tasks, look at the examples. They provide far more examples online than they do in the classroom, to me. Then the person is long-term learning the material, and that's, I would think, the ultimate goal is to focus on the material, not networking and things like that. It's more the material. Do you know what you're doing so you don't get in trouble later on? Not, buddying up or whatever. So I just think it should be an option. If some people want to go to class, some people want to do it online, I just think 40 other states have approved it, 40 plus, I don't know what the exact number, 43 or 45, I don't know what it is. But if those are part of your reciprocal states, wouldn't it be wise to have that same reciprocal education coincide with your state licensing? Just numerous studies from Berkeley to, just numerous places saying, a lot of people do significantly outperform students from attending in-room classrooms. It's just numerous data reports on that. The cost, just even coming down here, I had to drive from Texas yesterday to get here last night, today, and these are just receipts from this morning. You look at gas, food, all those things. Tennessee is not one of the wealthiest states compared to a lot of these other 40. I just think it would be wise if Tennessee is, they may not have as many white-collar corporations and things as some other states may have. It's not that wealthy state, so your residents may not be as wealthy. Why would you put them through things that cost more than other states? The convenience of online outweighs it, by far. I think I went over just the hotel, just the time. This class, I think that I'm trying to get approval for now. Somebody did offer, they must be, once again, like I say, in my area, I've asked everyone. This person here must be a really good person that said they'd give me an opportunity to train. I submitted my paperwork again. For whatever reason, it came back, and I thought I was going to be working and training. This is slowing us down because they said my paperwork wasn't any good. It was good. I've got everything from the University of Memphis saying that this class was approved by TREC. This was in 2009. I took it as a semester class. I didn't take it as a continuous ed or anything. It's a full class, just like everybody else that took the degree. They didn't renew it for whatever reason, which was out of my control. It was a state, It was the University of Memphis. It wasn't like it was from some third party, whatever. And I would think their credentials would be good for the 4 or 5 years needed for me to continue my path. Moving forward, say if it's not good, okay, I need to take the class. I don't have money to go, being below a trainee, since I'm not even a trainee at this point. I don't have money to go to, Michigan or DC and take off for work, pay for classes, for a class that I've already taken. Not to include classes aren't offered that frequent, even if you go out of town. I think the next one they have one in Chattanooga next month, but the next one from there is next spring. So if this person is needing a trainee, all this is just held up. And for what reason? I couldn't get a straight reason why, because if it was offered online, I could go get whatever class you want me to have and take it in a week and be done with it. And I think it's just a slow cycle compared to the other 40 that are progressively moving. I think if you invest in your trainees, you'll get a better product later. And that's pretty much what it all boils down to. I mean, you don't want to be wasting your time with a lot of errors later on because, in class they were focused on whatever else, getting to the next whatever, versus sitting down, looking at the material, learning the material, and moving on. Self-paced classes are exactly that. It's not moving at the pace of the professor. It's moving at the pace of the student. And different people move at different rates. I know some people think that online is, I'm about to wrap it up. I know you're
Okay. No, you're fine.
I know some people think that in class are better, but looking at a lot of this and taking the classes, it mimics a lot of the classroom. We can go put a note up. I put a note talking to two other students about a topic, and we communicate just like anything else. I don't know who they are. I don't know if they're, white, black, disabled, or whatever. Religion, I don't know what they are. But, it doesn't matter. We're looking at information, and, that's all should matter. You can talk to the professors. You chat. You can look at, before I even get to some of the other chapters, I can look and see what those questions already are that's sitting there that somebody, asked about. I can see the potential problem before even hitting it because somebody came right. You can't do that in the classroom. Some teachers may say, let's talk about that after class, or let's do, well, somebody else may have that same issue, but may not speak up in class, whether they, whatever. But that's all. I know you guys been here late, but that's pretty much it. I'm just asking for, I know continuous ed are approved. I'm just asking for QEs to be approved.
We got your application too late. Dr. Barilla is our education commissioner. He normally sits there. He's not there today.
Okay.
But he was not, I don't know if he had final exams. I guess it'd be about midterms, Mr. McDonald. So he was not able to process your education for this meeting because we just got it about 2 weeks ago, roughly. And so we don't meet in November, unfortunately, or fortunately, depending upon which side of the desk you sit on, maybe.
Every word right now is unfortunate, what you're saying. But,
well,
it's sad. It's really sad. But go ahead.
Well, I want to assure you that Dr. Barilla, assuming he's still the commissioner, his term has expired, but assuming he's still serving in that capacity, we will evaluate that decision in December, and we'll give you an answer on this education. But as for the online qualifying education, that's a matter before the commission now, and we're looking at potential rule changes. And so we hear what you're saying. We really do. And you make some really valid points. I think they're well informed, and we're very seriously looking at this matter because I think you're right. Personally, I think you're right. I'm not speaking for the commission, and I cannot. but we are seriously studying this issue. And I want you to know that,
Okay.
okay?
I appreciate it. I just hate now I've got to try to get the money to go to Chattanooga because I don't want to miss this opportunity. You know, it's a company and it looks bad. You know, I don't say I don't want to use anything about race, but unfortunately, that's the way I have to see things some way. This guy's giving me a chance. I said I had my paperwork. I submitted. He's looking for it. He sent it to the company out of town. And he's got to say, you know, hey, you know, they did fingerprint, they did background, all that stuff came back. And that, you know, companies pay for that stuff. And I have to sit there and, you know, I mean, he kind of went out on his limb for that, and it's just sitting there waiting. And, you know, for me, I look at it as, you know, man, this guy's trying to help me out. Black kid can't even get his stuff, and it's not my fault. But,
well,
you
and
know,
he can,
I mean, I know that's, but you have to understand that's the way I see it because that's what I've gone through. So, you know, regardless of the matter, I thought I had my paperwork. You know, for whatever reason, it's not, you know, if he was in a Mississippi or Arkansas, it was approved, I could say, hey, you know, give me a week, take the class, and be done with it. I can't do that for Tennessee. And that's just, you know, and now we're saying we have to wait till December because somebody else was out. It's just slow. When I say in the South it's slow, but that's just slow. It's just a slow process.
well, it may be that way.
It is. It is that way.
It may be, but that, to some degree, that's government. And whether you're applying for a business license or a driver's license or what have you, getting any kind of license takes forever.
But 5 years I've been trying. You know, I listen to you guys talk about these other trainees. I just wonder, you know, I'm sitting out here looking at the one, and I'm just thinking, I wonder if these guys had to go through half of what I had to go through. They probably didn't. You know, they didn't have to go through half of what I went through. And if they did, you know, I like to talk to them because I'm sure they didn't even try to go the first bit 5 years just trying to get my foot in the door.
I don't know. You know,
I don't know. I mean, I'm just saying it was three of them, and I just wonder. You know,
the rules are the same. Every member of this board has the same credential,
But-
and we all had to play by the same rules. I mean, we all did. I mean, there is no variance in those, right? I mean, there's not.
I have to disagree with it just because I've seen things in Memphis. And once again, Memphis, 70% minority town, 2%, less than 2% appraisers African American. I just think it's, once again, that is not by an accident. Because once again, once I left this meeting from the last time, I talked to a dozen other people. Yeah, I tried to become that, couldn't do it. You know, are you kidding? Why would you even be trying to do that? That's impossible. Go somewhere else. Look at something else. You're not going to get that in Tennessee. That's you know. I know you. It's weird me saying it to you, but that's the normal. I know it sounds like well, you know, maybe he's, but no. Because if you look at the numbers speak. You know. So, but I don't want to waste you guys' time. I'll just take the class and.
Commissioner Johnstone has a question for you, I think. Mr.
Well,
McDonald.
actually, I'm not sure. It's maybe a question for Keeling, possibly. From the procedures process standpoint, and Nicole, you can chime in, is for him to get his trainee's license, he needs one class to be approved. Am I off on that, or is that what's?
Yeah.
And it's a class that he took, but we haven't been able to get the matrix to work out. And my understanding, Dr. Barilla has got it, received it. Was the last thing to come in. He hasn't had a chance to review it because it came in near the end of the cycle. Is there a possibility? I don't know the answer to this. If he reviews it, since we're not meeting in November or December, is there a possibility for the board to approve that education requirement subject to Dr. Barilla's review and approval of it. And if he says it's okay, I would approve this, then rather than having to wait and come back in December, could he go on and submit that to you and then move forward with the process?
That's the commission's vote. I don't think that would be outside of your authority.
That's my question. But it's still contingent upon him approving it. And he may very well be reading it right now or tomorrow afternoon for all we know. He has the material. It's just that he's going to have to wait till December to come back and present it. And in an effort to help Mr. McDonald in this, in this situation, is that something that's within our dominion, more or less? And you're
I don't
saying,
think it's outside of your authority, so it's a determination for the commission to make, just like the experience subject to commission member approval, then that's how you vote.
Is the material that Mr. McDonald has submitted, is it complete? Do we know that it's all there?
I believe so, but I don't review the course material. Dr. Barilla does. So give him the information that we received. We try to do some basic checklists. And certainly we've communicated with multiple times on the application, the matrix, and some minimum requirements. And he's submitted it, the information by email, and we got it to Dr. Barilla as quickly as we could, but, you know, he is teaching full-time, so doing it, I thought that he would be able to make a recommendation, but apparently he was unable to review the material in time of this meeting.
Commissioner Johnstone indicated it's one class. Is it indeed one class, or are there several classes? Or
Other two classes were approved at the time he took it. This one class was not approved at the time he took it. It had expired in 2008 and didn't get eight matrix requirements. The school didn't submit it, so they let it expire. And it was expired when he took it.
or in the event we, can I speak?
Sure.
Thank you, Mr. Chairman. In the event we were to make some type of recommendation and approval subject to Dr. Barilla's review, is that getting outside the scope of the process that's involved to make sure that the classes are indeed set up and consistent with what the matrix says the requirements need to be? We would not be bypassing some criteria from that standpoint, would we?
As I understand what your intention is, it would be subject to Dr. Barilla making a recommendation for approval of the course. If he does that, then it would be automatically approved for Mr. McDonald, if that's the commission's vote.
And it could come back that he says, I've looked at the reviewed material, I think it would be approved, or he could come back and say, I think it shouldn't be approved. We don't know what his recommendation is going to be, but he could do either one, and that would at least let Mr. McDonald get on down the road and try to decide, I'm good, or I need to find a way to take this class somewhere.
Dr. Barilla makes a recommendation on that one item, we could document the recommendation and the minutes from the meeting if the commission correction.
Question. What type of precedent will this set in the event that we might hear a motion and we do vote affirmatively to allow this Dr. Barilla's review and recommendation and vote subject to, will this set some type of precedent for future late applicants, whether they be education or experience?
Yes, it would set a precedent, because I'm not aware of any other education that's been approved in this manner, but it certainly doesn't come up that much so far as students taking courses that are not approved at the time that they're at the time they took it. So it's an unusual situation. I hear and understand Mr. McDonald's frustration, but we have to apply the education that rules that are in effect at the time that the person applies. And at this time, the commission requires qualifying education to be pre-approved from the board, or that they go through the individual course approval process, which he has, but we just don't have a recommendation and vote to the full commission yet.
The University of Memphis said, I took the class, completed the class April 2009, and from her outline of the class, she said it was approved by the commission 2009. But you
2008.
It was
It
approved
expired.
2008.
It was approved prior to 2008. It expired in 2008.
Okay.
So if you took it in 2009, that would have been a year after its expiration. A year
Okay.
and some change.
Okay. Are we sure that that happened? Because remember, I applied and I had a trainee's license. So if that was the case, which I think the school was not saying that I don't understand what you mean by it was expired when after 2009, I applied for my trainee and I submitted those classes. We all submitted those classes and they were approved. So how is it?
The course was expired in 2008. The school didn't resubmit for approval. I don't know how or why your previous application may have gotten through. I don't know what education you submitted at that time, but for whatever reason,
Right.
it wasn't approved, and we've documented it clearly that that course expired. We printed out even the,
Right, and that's what the school keeps challenging you on, because they said that they have the outline. When I asked them for the outline, they said, well, Glenn, the state has it. They said they submitted it. They said, you wouldn't have been able to take this class if it wasn't approved. They would not have been able to publish it at the University of Memphis as an approved class. And I wouldn't have taken any class that wasn't approved. And this was 2009.
your email chain even indicates that from the school, that they elected not to renew it after 2008.
No, it didn't say after 2008. It said after. It actually didn't say a time afterwards. It just said after that, the real estate department was discontinued. They didn't renew it. She didn't put a date on that. She just says, Glenn, you took class from February 10th, finished 09, 30 hours.
That course was never submitted for qualifying education for the new 2008 matrix requirements that moved. It was previously approved under the old system for qualifying education, but the school elected to not renew it on the new requirements. They never submitted a matrix.
Sounds like to me that the materials that the university provided you in '09 were out of date, in the sense that they said it was approved, and it had been, but the Federal Appraisal Qualifications Board came out with new rules effective 1 of '09. So everybody had to resubmit, and apparently University of Memphis opted not to.
1 of
That's-
08. 08. It
I'm sorry,
changed the-
1 of '08, I misspoke. So when they said it was approved, should have been emphasis on was. So,
Yeah, I appreciate Mr. Johnstone. If I could know as soon as possible if I need to take the class over in Chattanooga.
well, we won't know until Dr. Barilla reviews. We keep talking about this matrix, and apparently you're very familiar now.
Right.
Until Dr. Barilla reviews that body of facts, we won't know whether you'll have to retake something. And if Commissioner Johnstone wants to make a motion, he's certainly free to do so. Or anyone
Well,
else.
I don't see it as, there was a good question about, are we setting a precedence here? This is such an unusual situation that I think that the likelihood of somebody submitting something to Dr. Barilla that doesn't get reviewed before it comes to the commission, and them have taken a class 5 years ago, there's just so many variables involved that I think it would be hard for somebody to point a finger and say, you've set a precedent here. I think we could probably do that and still retain a lot of autonomy in not setting the precedents. Because one, Dr. Barilla already has the information. He just didn't have an opportunity to get it done because it came in at a late time. Generally, we're going to meet every month anyway, or lots of times we meet month to month. And it doesn't sound as if Mr. McDonald is trying to get around the process. He's just trying to decide, do I need to go take a class, or the class that I took, is it sufficient? It just hasn't been plugged into the matrix. So with all that, in my mind, I don't see it as being something that we're going to have to wrestle with every month with somebody new coming in. I could be wrong, but it doesn't seem to me that that's going to be an issue going forward. It's just going to, every time we turn around, somebody's going to want to come in and do that. I mean, am I missing something? How many individual requests do we get for qualifying education?
Not that many each year, maybe, I don't know, 5 or 6.
5 or 6?
It's usually somebody who took a class in another state. I can't even think of a time it's been inside the state where the school didn't get their course approved for that time period.
How often do we receive material that needs to be approved for qualifying ed or continuing ed that does not get reviewed before the meeting, that gets pushed off?
Dr. Barilla reviews things very quickly, sometimes even the day of a meeting if he's here.
To me, it just
he's
seems
been
like an
very
unusual
accommodating.
situation. I mean, it's just
yeah. He's just not here this month, so it makes it more difficult, if it was, generally speaking.
I'm going to make a motion. It may get a second, may not get a second, but I would move that we allow Dr. Barillo to review this. Well, let me start over. I make a motion that we approve the qualifying education contingent upon Dr. Barillo's review and approval of the matrix for Mr. McDonald's specific situation in regards to his class from the University of Memphis. And with that, give Director Avers the ability to continue the processing of the trainee license without reconvening if Dr. Barillo approves the education.
Second that.
Okay, so we have a motion to approve the QE subject to Dr. Barillo's recommendations. And we have a second. We have a motion from Commissioner Johnstone and a second from Commissioner Walton. Is there further discussion?
And that communication can be electronically transmitted to Director Avers based on his response. It doesn't have to, I think that was implicit in my motion, but just for clarification purposes.
That would speed up her ability to notify Mr.
Right.
McDonald.
I said without coming back to this body, which meant, but he can certainly, rather than mail or certified mail, he can communicate that electronically, which she indicated he typically does that anyway.
Further conversation or discussion? No? All right. Motion and a second. Hearing no further discussion, all those in favor say aye.
Aye.
Those opposed, that would be me. Motion carries. All right. Is there any further business?
Opposed?
Yeah, I have a number of reasons that the primary reason, Mr. McDonald, is the precedent And here's the thing. Well, maybe Dennis will hold it up. Dennis, will you hold up the stack of reports that I reviewed for this meeting? Okay. That's half of our typical workload. Half. So normally for one of these meetings, I read that volume of work. And that's submitted to me. Usually I get it about 3 weeks prior to our meeting. And I can tell you that's a burden for me to get through. I'm a working appraiser, and that's a real burden to get through. There are folks that get their material in on time and don't make it to the regular meeting. They don't make it through to the regular meeting, and we don't change the rules for them. So
I don't think you guys know the whole. I actually sent the material in more than 2 weeks ago. It wasn't me just submitted in. It was for some reason it was undetected. I think they may have thought it was the same PDF, but I'd updated it and I sent it in over. It was actually supposed to be voted on your last 9/16 meeting.
Okay.
I don't know if that's precedence or not, but
well, I wasn't aware of that.
Right. So
is I don't know if that's the case or not, but based upon the facts I have, it would appear that we've changed the rules for you, Mr. McDonald, and it's the vote of the commission that we do that, and I have no problem with it because I believe in the process, but I exercise my right to vote against, and that's fine. It's no problem. I wish you the best. I really do. I hope that this, and I direct this to my fellow commissioner now, I hope that this change doesn't come back to make all of our lives more difficult. So
I doubt if this will probably ever happen again. It's very rare that he's missing, and like I said, I submitted it more than 2 weeks ago.
no problem. Well, we've hopefully we've accommodated your progression, and hopefully you can get the credential and go forth and prosper.
Yeah, I hope so. Thank you, everybody.
Thank you.
I think the next class is November the 1st, so.
Excellent. Thank you. Thank you for your time. Thank you. Okay. Is there other business before the commission? Okay. Hearing none, we stand adjourned.